Good morning, everybody. Good morning. I am Jerry Roth, the president of the UIA. I say good morning because I am in San Francisco, although I know that many of our speakers this morning, and we have a terrific panel for you on the Schrems decision, as well as many of our participants are joining us from around the world. So thank you so much for being here. I just want to mention that we've started off the new UIA fall season with a bunch of activity, a number of terrific webinars like this one. In particular, I want to mention two. One is our Women Bar Leaders Day. We've been celebrating women bar leaders around the world with some terrific speakers. Yesterday we did our French session. We have our English language session next Wednesday, and we have the presidents of the major UK bars, the Hong Kong Bar, the American Bar Association, and others. So please check out our website. I think it's going to be a fascinating session. And we have our Spanish language version of it the week after that on the 23rd. We also have our virtual Congress coming up on October 28th, 29th, and 30th, 3 days around the legal world. There it is. And it's going to be an amazing event. We're able to do some things virtually that we cannot do live. So while we'll miss seeing each other, we will be able to present some things in a format that I think all of you will find exciting, interesting, and worthwhile. So I hope you'll join us then. With that, I am going to turn over the mic to my good friend Ann DeFreitas, who is going to be our moderator today. Thank you all for being here, and I wish you a wonderful session. And I will click off and observe from the back rows, as they say. Thank you, Ian.
Thanks, Jerry. Look, I'll just start by introducing what is a fantastic panel. So first, we've got Elizabeth. Elizabeth's a partner at Van Doorn in the Netherlands, and she leads their privacy team there. She's a board member of the Dutch Association of Privacy Lawyers, and she has a large number of publications, including various well-received books and presentations to her name. She's also an editor of 2 specialist law journals. I'm amazed she has time to do any lawyering work, but there we are with all of that. She is ranked in various international guides, highly ranked, Tier 1 in Chambers and Legal 500. And in 2019, she was a finalist for Legal Woman of the Year. And then next we've got Axel. Axel is a partner in Beiten Burkhardt from Munich. He's a member of that firm's management board. He advises national and international companies on data protection issues, and he's also an expert on technology, e-commerce, and copyright issues. He's also a lecturer in media and information law at the Faculty of Law at the University of Munich. And then finally, we have Grant from Mungertolls and Olson in Los Angeles, also Jerry's firm. His practice covers complex commercial litigation, data privacy, information security, and he has a particular focus on compliance with the California Consumer Privacy Act. He's written and spoken on the comparisons between that new Californian law and the EU General Data Protection Regulation, which obviously is front and center of our discussions today. Just in terms of what we're going to do today, we appreciate that the audience is mixed. There'll be people on this capsule who are real experts, quite apart from our panel, but then there'll also be some people who are starting from the ground up. So we're going to start with some building blocks. Then we're going to explain the Schrems decision and its implications. And then we're going to reflect on some of the practical guidance that we've been giving to our clients and some of the guidance that we have seen. There is a Q&A box. Tom Rudkin, my colleague, is going to keep an eye on that. Please put your questions in there. We won't take questions as we go along, but we will get to them at the end. We'll try and leave 10 minutes for that. Tom's going to be monitoring it, and he's going to be selecting the most interesting ones, so please make them interesting. Okay, so let's turn to our panel and get into the Q&A. And this is a Q&A, no slides, so we're going to have a conversation about this. And first, the background to Schrems. We thought we would start there, and really the first building blocks. Elizabeth, could you start us off just by explaining the basic position in relation to organizations who want to transfer personal data from the EU to third countries?
Yeah, thank you, Ian, and also welcome to the public, so all the participants. Let's start with the basic. So if personal data stay within the EU, or rather the European Economic Area, which is 27 member states plus Iceland, Norway and Liechtenstein, then there are no problems. At least then you only have to fulfill the normal privacy rules, but not the transfer rules. But once you transfer data either directly to a third country, so a third country from the European perspective, then you need to comply with the transfer rules. And that can also be done indirectly, for example, via a sub-processor. And let me explain that with some examples, because many organizations are not aware that they are transferring data from the EU to a third country. A first example would be the outsourcing of your service to a service provider in a third country, for example, the US. Then it's clear that if you use the service provider, then there will be processing of personal data, and then the data will be transferred. Another example is that your service provider is in the EU, but there is a subcontractor of this service provider, and the reason for that is most cases for cost reasons, or for that they want to provide the service 24/7, so all around the clock. And then in that case, for example, if you use a cloud provider, or if there would be support with a subcontractor, then this also constitutes a transfer of personal data. A third example is that the surveillance programs, for example, of the US, have extraterritorial effect. So also in that case, then you have to deal with the transfer rules, because then even if your personal data stay on a server in the EU, they can have, through this surveillance program, then you can have a transfer of personal data. The last example that I want to mention is if there would be an intergroup transfer. So within multinationals, there can be affiliates or branch offices all around the world. And then also in that case, personal data is shared between these different establishments. It can be employee data or customer data. And also then you have the transfer. So transfer is a broad concept, and it's good then to be aware of that. So in most cases, companies are not always aware that they are transferring personal data to a third country.
Okay, and Elizabeth, could you just explain as well for the audience what some of the typical gateways are which allow you to make these transfers from Europe to third countries?
Yeah, so as I explained, so there are different situations where you are transferring personal data to a third country, and then you have to legitimize such transfer by a transfer mechanism. And these have been described in the GDPR, so the General Data Protection Regulation, in Chapter 5, more specifically, Article 44 and onwards. The first one, and there's a ranking order, that's also good to know. So I will start with the first one, that's the Adequacy Decisions. There are 12 countries which are on the list of the European Commission. The European Commission investigated the country and looked at it, whether they are providing an equal level of protection as the GDPR. These examples of countries are Argentina, Israel, New Zealand, Switzerland, and most recently also Japan. Also the safe harbor and later the predecessor, so the successor privacy shield was also on this list, and we will discuss the history of these frameworks later on. So that was not about the country, but about companies who adhere to them. So it was US companies. And the adequacy decisions are still valid, but they are evaluated on a regular basis, and they can also be invalidated at a certain moment. But for the countries, that has not happened yet, but for the framework, privacy shield, and also for the safe harbor, that happens. So if there is no adequacy decision for a certain country, then you need to look at an alternative, and these are the standard contractual clauses, at least one of the alternatives. And there we have then 3 versions. You have to look whether the data importer, so the receiver of the personal data, is a processor or a controller. So what privacy position this importer takes, and then you have to look at the controller to controller, standard contractual clauses, or the controller to processor. And from the controller to controller, we have 2 versions of 2001 and 2004. And of the controller to processor, there's 1 version of 2010. And we will discuss that later. Then another possibility is binding corporate rules. That is, if you would transfer the data within a multinational, so within the group. And there we have 2 versions. That is the controller version or the processor version. So this only applies if you would only transfer within your own group of companies. And then the last one, which is in a hierarchy, so at last, so the rank of the bottom, is the Article 49 derogations. So that are certain derogations for specific situations which you can use. And 2 examples are the consent of the data subject, or if there will be an agreement with the data subject. And an example would be, for example, that the travel agents need to transfer data of consumers to a hotel in, for example, China or another third country. And then in that individual case, you could rely upon the derogation. But these have to be interpreted very strictly. So now we have a few of all the transfer mechanisms that are the most important one, at least, that you can use to legitimize the transfer.
Okay. Thanks, Elizabeth. That's a great explanation. Just coming on to transfers to America, we've had, Elizabeth mentioned adequacy decisions, and we've had 2. One was called Safe Harbor, and then we've had the more recent Privacy Shield. Grant, could you just explain a little bit about the history of those mechanisms?
Sure. And let me just echo Elizabeth's welcome to the audience. I hope everyone and their families are doing well. The history here really goes back 25 years to 1995, when Europe adopted their data protection directive that had sort of these concepts that Elizabeth has been describing that restricted transfers outside of the European area unless there were essentially equivalent protections. And so since then, the United States and Europe have been trying to come up with a structure by which US companies could essentially agree to abide by stricter privacy protections than we typically have here in the United States, and thereby use that as a data transfer mechanism to get data from Europe to the United States. And the initial attempt at this was called Safe Harbor. It was negotiated in the late 90s, and it essentially had 7 privacy principles that companies could sign up for and sort of self-certify to. And by doing so, they subjected themselves to investigation and enforcement by US agencies like the Federal Trade Commission if they were to violate the principles that they had agreed to abide by. And in 2000, the European Commission took a look at this safe harbor framework and issued an adequacy decision. Essentially, it found that this safe harbor approach would provide equivalent protections to those that are provided under European law that was in effect at the time. The following year, of course, we had 9/11. And in the aftermath of 9/11, the Bush administration here in the United States undertook a wide-scale surveillance program. And that obviously began to raise concerns, and those concerns sort of came out over the next decade. But between 2000 and 2015, US companies were able to rely on the safe harbor if they signed up for it as a mechanism to transfer data about EU data subjects from Europe to the United States. Then we get to 2013, and in June of 2013, a 29-year-old named Edward Snowden decided to release a series of highly classified documents to reporters from The Guardian and The Washington Post. And those documents essentially revealed pretty startling details, I think it's fair to say, about the nature of these surveillance programs, the amount of data that they were collecting, who they were collecting data about. And essentially they revealed that there were two major programs that have gotten a lot of attention and that still get a lot of attention, one called Prism and one called Upstream. Prism allegedly allowed the US government to collect and search through extraordinarily large volumes of data that were being held by certain companies that had been ordered to produce that data to the government. And Upstream involved the US government and other governments, by the way, tapping into various parts of the internet backbone to search and filter for what were called selectors, or essentially key terms that they were looking for, as well as identifiers for particular individuals. And so later that year, after those revelations came out, the European Commission issued a report finding that the transfers of data that were being enabled by Safe Harbor were likely leading to more government surveillance and more government interception of data about EU individuals. And in 2015, the European Court of Justice was asked to consider the validity of the Commission's 2000 decision that had found Safe Harbor to be adequate. And that case was brought by an individual named Max Schrems, an Austrian lawyer, a data protection advocate, who sought to prevent a social media platform from transferring his data to the United States. And in that decision, the ECJ essentially held the Safe Harbor program to be invalid for a number of reasons. But at a high level, the ECJ essentially found that the Commission's 2000 decision had not included sufficient findings regarding adequacy and regarding the issues that were raised by the US government surveillance program, that the adequacy decision had not been updated to account for new facts, that the 2000 decision had improperly allowed US national security and public interest and law enforcement requirements to trump European data protection interests. And on top of all that, that there really was no effective mechanism for EU data subjects to challenge the surveillance programs of US government practices. So the upshot was that as of 2015, companies could no longer rely on the Safe Harbor framework to transfer data from the EU to the US.
Okay. And then just coming on to Privacy Shield, my understanding is that came after Safe Harbor, and it was the US government, the EU Commission getting together again and coming up with a strengthened form of Safe Harbor, if you like, and then putting that together, and that seemed to operate for, well, it did operate for a few years, but then came under challenge again. Now, just turning to Axel, this is what was the subject of the Schrems 2 case. So what we initially had, as I understand it, was a challenge to the use of standard contractual clauses by Facebook, because when Safe Harbor was invalidated, Facebook switched to standard contractual clauses as a gateway. But then added on to that was later a challenge to the new Privacy Shield, which the EU and the US had negotiated. Axel, could you just explain, and that challenge went to the Court of Justice of the European Union, and we recently had their ruling back in July this year. Axel, could you just explain what the court decided regarding the validity of Privacy Shield and why they came to the conclusions that they did?
Yeah, first, a warm welcome from my side, last but not least, and thanks for the opportunity. Yes, the Privacy Shield, as Grant already mentioned, this is the replacement, or the try of replacement of the Safe Harbor concept, and it's also an adequacy decision, and the court took the opportunity to also review that adequacy decision regarding the Privacy Shield, And again, the court had concerns with the surveillance programs in the US. So it all gets back to the surveillance, and the finding was similar to the safe harbor decision. They invalidated the adequacy decision. In fact, they said it's not an adequate level of data protection. And what the court did, it took the fundamental rights of Europe laid down in the Charter of Fundamental Rights and tested the decision against that fundamental rights. And they found deviances from this fundamental rights that they led to the decision that this adequacy decision has to be invalidated. Why did they do that? First of all, and Grant might chime in, it's a reference to the US law, and it's a reference to the law on the intelligence services of the United States. And in a nutshell, there are three major points that makes the privacy shield unacceptable from a European perspective. First of all, it's Section 702 of the Foreign Intelligence Surveillance Act, called FISA. And the court found that there's a lack of limitations for surveillance measures, and there's also a lack of guarantees for non-US citizens. So they took the perspective from a European citizen and asked the question, would they have similar rights, similar remedies as they would have under European fundamental rights? And they found no, there is no sufficient guarantees for the US EU citizens, and that's reason number one. The second reason is quite similar. It's there are presidential and executive orders, and also those executive orders are the basis for, correct me if I'm wrong, Grant, is it Prism or is it Upstream? But one of them is based on the presidential order. And again, there are too intrusive, they lack limitations, and again, outside citizens of the US lack the opportunity of legal remedy for that. And a third point, the Privacy Shield installed a role that is called the ombudsman, an ombudsperson, and this ombudsperson, from a European perspective, should be an independent monitor person to take care of fundamental rights and guarantees for data subjects. And the court found that this ombudsperson lacks of independency. It was too close to the executive administration, and for formal reasons, they said this is also something that is not in compliance with fundamental rights in Europe. So summarized, lack of guarantees and lack of independence made them invalidate this privacy shield, this adequacy decision, and it's null and void. It's effective of the date of the judgment, and that's why we can't not rely anymore on that.
Okay. So Privacy Shield invalidated. Coming back to Elizabeth, because the beginning of this case was in Schrems 2 was about the standard contractual clauses. So Privacy Shield invalidated. We think, well, standard contractual clauses must be in difficulty. But what did the court say about the standard contractual clauses?
No, here luckily they stated that they are still valid. The judge focused then, so the court focused on the controller to processor. So I explained that there are three versions of standard contractual clauses. So the controller to controller, where we have two versions, and the controller to processor, one version. But actually, you should, it's not only about the controller to processor standard contractual clauses. So the effect of the court decision is much broader. So it's about all three versions. And when you read then the decision, you see that it imposes then an obligation on both the data exporter and the data importer to verify the transfer, and in 2 phases. So prior to the transfer, then you have to perform a due diligence. And once you are transferring the data, you have to monitor what kind of data are transferred and what additional measures need to be taken. So when in the prior to concluding the standard contractual clauses, you must ensure that you have the level of protection that is essentially equivalent to what you have under the GDPR. That need to be guaranteed, and you have to look at the content of the standard contractual clauses, specific circumstances, what legal regime applies in the destination country. And once you have done this prior assessment and you have concluded the standard contractual clauses, then there remain obligations on both parties, so the data exporter and the data importer, to inform each other whether there are any changes in the destination country. And if so, you may have to suspend the transfer or even stop the transfer. And then the data need to either to be deleted or to be returned to the data exporter. So we see that the standard contract clauses before the decision, they were just paperwork and signed so in connection with the data processing agreement or with the controller to controller agreement. But now you need to be more critical and really look what you're doing. And so it's really, so it's not a paper exercise anymore, but it's see whether what kind of measures you should take, and we will discuss that later, what decisions we would recommend to do so. It's also good to know that the decision is about the validity of the privacy shield, so which is invalid, and the standard contractor clause is still valid, but you need to do extra work there. But also there is a task for the supervisory authority to enforce any infringement. So if the additional measures have not been taken well, then the supervisory authorities, they have to take an action. They have the power to either prohibit or suspend the transfer. And the court also point out that there will be that there is a consistency mechanism under the GDPR on the basis of which so the supervisory authority considering the prohibition to a particular third country can refer then the matter to the European Data Protection Board, so which was previously the Article 29 working party, or also in order to avoid that in different countries we will have different decisions on what would be the measures.
Okay, and then that actually leads neatly on to, so this was a surprise for everybody, and so Axel, we would think that the European regulators would be ready for this, but what have they said? What have the European regulators said, these supervisory authorities, about transfers relying on Privacy Shield and standard contractual clauses in light of this ruling? What have you heard from them?
Yeah, so to recall it, the judgment was of 16th of July, and there were initial reactions of, let's call them local data protection authorities, or in particular in Germany, some of the state authorities issued first opinions on that, but there was not really much information in that. And Europe was quite fast, and the European Board of Data Protection Authorities issued on a week later. So it was for European scale a really fast thing. And I would say that's was a guiding document. And I spoke to the German participant of that working group, and to get this sorted. This was made on the basis of legal discussions only. There were no technical people involved in that process, which might be an interesting information later on if we deal with possible solutions. What did they say? They said there's no grace period. So this is the law as of the judgment. So no grace period for the privacy shield, no grace period for applying standard contractual clauses. And the judgment relates to the privacy shield and to the standard contractual clauses, but the Data Protection Board took the position that the principles of the judgment would apply on all guarantees in Article 46. And companies in particular have to be careful to transfer data to the US. So there's a focus on the data transfer to the US in that document. They deal with that. And they also emphasize that binding corporate rules might be treated similar as to the standard contractual clauses. As Elizabeth mentioned before, multinationals relying on binding corporate rules should also look into their binding corporate rules and assess whether or not they're a feasible gateway to the US in the future. And they suggest, and that's certainly a legal position, that you might take additional measures to safeguard your data transfer to the US. And this should be subject to an analysis on a case-by-case basis. So they push the ball a bit forward. It's not a really helpful information, but that's as we are. And they also say that you should look into your contracts with your data processors. That's what the European Data Protection Board says, and the German authorities then agreed to that. And so from a continental European perspective, I would say the frequently asked questions, this document of the Data Protection Board still forms the basis for the understanding of the data protection authorities, but maybe the ICO has.
I should mention in the UK, the Information Commissioner's Office originally said that the Privacy Shield could still be used until we see what happens, but then withdrew that when they saw the European Data Protection Board's guidance. So they're firmly behind that as well. Just to mention as well, quite interestingly, Max Schrems' organization, which is called None of Your Business, NOYB, became frustrated at the lack of clear regulatory action and has issued 101 complaints in 30 different countries, complaining about specifically continuing transfers by Google and Facebook, but drawing in the data exporters who are using Google and Facebook to make those transfers to Google and Facebook in America. And we are waiting to see what happens with those claims. But just last night, we have seen reports that the Irish regulator, who was at the center of the Schrems 2 case, because that's where the complaint was first made, has apparently issued an interim order to Facebook to stop data transfers relying upon standard contractual clauses. Now, that's press reports. I haven't seen that order issued, but we wait to see. So there is pressure building for regulators to take action, despite the fact the regulators haven't given us any full guidance yet, which is a bit unfortunate, let's put it that way. Cart before the horse, as we say in England. Right. Just in terms of reactions from not just regulators, from governments. Grant, could you say something about what the US government has said and a little bit about the EU Commission?
Sure. You know, both the US government and officials in the EU came out with statements the day that the Schrems decision came out, which I think is a sign of how significant it is and how much concern there was about the economic ramifications of the decision. And, you know, both sides, I think, were clear to try and reassure people that cross-Atlantic data transfers would continue in the aftermath of this decision, and that both sides were committed to data protection. On the US side, there was also expressions of deep disappointment in the decision from the US Secretary of Commerce and guidance from the Secretary of Commerce that companies that had signed up for Privacy Shield were still bound by the principles that they had signed up for. In other words, they could still be subject to enforcement here in the United States if they were to violate those principles, even though they could really no longer take advantage of the main benefit of being in Privacy Shield. On the European side, there was a confirmation that they interpreted the decision to allow for standard contractual clauses to continue to be used for cross-border data transfers, and an indication that the Commission, and this I think had come out before, but that the Commission was working on updating the standard contractual clauses to address both new developments in the GDPR and now to address the Schrems II decision. And then about a month later, the Secretary of Commerce and the European Commissioner for Justice came out with a joint statement indicating that they had begun discussions to evaluate the potential for a new Privacy Shield framework that would try and address the Schrems II concerns. When you dissect what they said there, it's a pretty tepid statement. They said that they had begun to discuss the potential for being able to come up with a framework that might might address the Schrems II concerns, which I think, you could reasonably interpret as being a pretty sad sign about how difficult it's going to be to come up with a Privacy Shield-like approach that satisfies both Europe's adequacy requirements and its data protection requirements, and at the same time, the United States' interest in continuing its intelligence programs.
So at least they're talking, that's one thing. Or beginning to talk, let's put it that way, with a view to doing something. So in this sort of, the environment we're now living in, there's lots of uncertainty. So I thought we'd turn towards thinking about what we could give as guidance, practical steps that organizations who are continuing with these transfers, want to continue with these transfers, what steps could they take? So in light of all of that certainty, what do we suggest organizations do now in terms of transfers of personal data to America? I mean, Elizabeth, do you have any thoughts on that in terms of the practical steps that perhaps you're advising people to take now?
Yeah, we got a lot of questions of our clients, and some of them are just waiting and see what happens, and others are really taking this seriously as it has quite an impact on the organization. We try to help them as practical as possible, so therefore we drafted an Excel sheet in where they can map all their data transfer. So most of the companies already have an internal processing register based on Article 30 of the GDPR. And this internal register, they already have, if they have done the job well, they have put all the transfers in that register. But we made it now specifically for the Schrems II case. And in this register, you can map then so all the countries, all the transfer mechanism, what is the duration of the agreement, so and to have you can prioritize the most important transfer, whether it's necessary to change to the EU or if you can really continue to transfer the data. So that's a thing that we drafted, and we also drafted a step-by-step plan. Which helped them to check what needs to be done. So depending whether it's on a Privacy Shield or on standard contractor clauses, or whether they can rely upon a derogation. And then, so it's a step-by-step checking, and especially also document what you were doing. And then the additional measures which can be thought of is changes to your agreements, to the standard contractor clauses, to the processor agreements, technical measures which you can think of, like encryption or data localization. So also technical and organization measures should be considered, and otherwise, if there's no solution, then consider either to suspend the transfer until you know what to do. But first it starts with documenting and see what you have and yeah, in what and also make a time because it was invalidated immediately, as Axel explained, upon 16 July, the privacy shield at least, and so you cannot wait for and we are not aware how the enforcement will work. Yet.
Okay. And Axel, I mean, just on the sort of more the technical side, I mean, there's mention of encryption and perhaps storing data in Europe and not transferring it to America. You got any views on that? I mean, whether that is viable?
And that's the crucial point, that if we focus on the US, we have a ruling that says no privacy shield, and it says no standard contractual clauses for a transfer in the US. That was defining what to do. And also the FAQs of the Data Protection Board, of the European Data Protection Board, only deals with legal issues. That's because it was negotiated by legal background people. And the thing is, what could you do on the technical side? And if you refer to the reasons for the judgment, the reasons are not within the clauses itself. The reasons are in the legislation regarding surveillance in the US. So we can't change the legislation of the surveillance in the US. And that's why encryption might be an option. However, German authorities suggest that this encryption must be, let's say, NSA proved. There shouldn't be a possibility for a US intelligence service to get the key for that encryption. So that's a technical question. I'm a lawyer. I don't know whether or not that works, but an end-to-end encryption might work. And another thing that you might consider from a technical and organizational perspective might be tools of anonymization. So if there is a way of anonymizing data or pseudonymizing data with the key staying in Europe, that might be a workaround. But this, again, it's all a solution on a technical basis, not on the legal basis. And we will see whether or not there will be some guidance from authorities or from Europe how to work with technical solution on that problem.
Okay, Grant, have you got any sort of comments from the other side of the pond, as it were, in terms of what Elizabeth and Axel have suggested?
You know, I think their advice is great. I would just add, I want to acknowledge that this is a really difficult problem. That if you look at this and you say, well, what am I supposed to do now? I can't control US government surveillance practices. I can't enter into a contract that restricts how the government reviews data or captures data. You're not alone. I think a lot of us are looking at this and viewing this as essentially a foreign affairs problem and a real divergence between the United States and Europe over how to protect data and at the same time conduct necessary surveillance for national security interests. That's really now being fought out in the commercial arena between participants who, in a sense, can't control the problem that's trying to be solved. And if you sort of think about it from the perspective of businesses that are trying to comply and trying to make these assessments of the US surveillance regime, one of the problems that arises is how are they supposed to know? I mean, a lot of the details are secret for very good reasons. So it's very difficult to know whether your data, for example, is being captured. Some businesses might know if they've been subject to a FISA warrant or a FISA order. But in the case of upstream, for example, businesses have no way of knowing whether the government is tapping into transatlantic cables or a station somewhere that their data is transferring through. Private companies have no way to know what search criteria are being applied by the US government to filter out the data. And private companies also have really no way to know whether the risk of, whether that transfer of data from the EU to the US meaningfully increases those surveillance risks. I mean, keep in mind that surveillance doesn't happen just when data gets transferred from EU to the United States. Surveillance is occurring all over the world, and data transfers even within the EU may be subject to programs like Upstream being conducted either by the United States or the UK or other members of the Five Eyes partnership. And so all of these are questions that I think are very difficult for US companies to assess. And then on top of that, they've got to try and figure out, well, what can I do with standard contractual clauses or my binding corporate rules to address these concerns that the ECJ expressed in the Schrems 2 decision about the United States government surveillance program. So that's sort of some pessimistic comments, but I think, with all that in mind, yes, you can do things like encrypt data, anonymize data, keep it in the EU, but let's just be honest about the fact that all of those solutions have their limitations, their problems, their weaknesses that make them oftentimes inferior to using standard contractual clauses or binding corporate rules or the privacy shield as your data transfer mechanism.
But I mean, I'm certainly saying to my clients, don't sit there and do nothing. Don't wait for the regulators to come up with something. You've got to be doing something proactive, at least to start this process of making these assessments. So that the regulator comes to you and say, we're trying to do something. It's just we haven't quite got there yet. And just on that, it's interesting what you said about, this goes on internationally. So Axel, this isn't just about transfers from Europe to America. It's about transfers to other third countries as well, their impact. Do you just want to say a little bit about that?
Yeah, certainly all the discussion is around the transfers to the US, but as you can see from the reaction of the authorities, that they take this as a general principle and a general risk assessment, and that also applies to other jurisdictions. So if you transfer data, for example, from the EU to Russia, or from EU to China or any other country, you have to bear in mind that you have to comply with those principles. So if there is not an adequacy decision in place, like for Israel, for example, if there's no adequacy decision in place, you need to check whether or not you can rely on standard contractual clauses against the background and against the legal background and the factual background of the data importing jurisdictions. So all these principles we discussed earlier would apply to those jurisdictions as well, which multiplies the problem globally. Yeah,
and just to mention there as well, because I'm sitting in the UK, we are about to end the transition period with the EU. We become a third country. Yeah. We have no adequacy decision at the moment, so we have no adequacy decision mechanism. That may not be granted, and particularly with the way the trade negotiations are going, it looks unlikely. So we rely upon standard contractual clauses, which we are importing, but the exporters from Europe will need, and they'll need to make an assessment of our national security laws, which are not unlike the American laws. So that could be quite difficult. But we're
watching you, so.
Yeah, exactly. Thank you, Axel. But we think we're slightly better than the Americans, but we'll see what Max Schrems and others think about that. I don't know. So that's a problem for us with Brexit. Another problem with Brexit. Look, we're getting close to time, and I just wanted to just ask you guys a question before we get on to questions which Tom has been looking at. Just ask you a question about some of the longer term impacts. And Grant, you were touching on this. I mean, we have these three things in play, as you mentioned. So you've got the commercial wishes to transfer data globally. You've got the privacy concerns, which are quite legitimate. And then you've got the concerns of governments for national security purposes, which are equally legitimate. And it's this question about, you've got these three things, and Europe's going one way on the privacy side of things, and America's still in its national surveillance mode, and the commercial world is in turmoil in between. Do we think there's any way that we can draw those three things together and come up with a common, at least transatlantic view, which, Americans will relax national surveillance, for example? Grant, is that feasible?
I gotta confess, I'm a little skeptical for a whole variety of reasons. I mean, look, these programs, at least as of 7 years ago, when when we got some glimpse into what types of data they were collecting and how important they were to the U.S. government's national security and intelligence programs. I think the intelligence community views them as very important. I mean, I don't think these are minor parts of their overall strategy for detecting threats to national security. So for that reason, I think it's very unlikely that they are going to quickly let go of these tools, just because of the Schrems 2 decision. And, if you look at it from the perspective of elected officials here in the United States, the notion of changing our intelligence gathering practices or putting our national security at risk because of a decision of a European court, that's going to be a tough sell to the electorate here in the United States,
exactly,
to put it lightly.
Yeah,
particularly now. So
not before January anyway.
Yeah. And if you look at what would need to be done to address the concerns of the ECJ, for example, giving Europeans the right, apparently, to bring challenges here in the United States to the surveillance practices of the NSA. Well, we don't have those rights here in the United States as US citizens, by and large. I mean, it's very difficult for us to bring that type of challenge. So the idea that those rights are going to be granted anytime in the near future to EU data subjects, I think is unlikely. So there's going to have to be some compromise on both sides if we're going to get to a solution.
Yeah, and Elizabeth and Axel, do you think there's any compromise from the European perspective in terms of us perhaps revisiting our privacy laws and the national security issues and the commercial considerations, and perhaps relaxing our stance on privacy?
Yeah, that's difficult. Indeed, we have to find some kind of compromise because we are dependent from each other. So we have the different angles. We have the privacy, but we have also security. It's like now in Corona with the health and the privacy. So it's a different kind of controversial to find a way that things come together. But I assume that at some time we will have a new kind of privacy shield mechanism, possibly because there are so many commercial interests involved here, and so we need to find each other on how that But for us as lawyers, it is always helping the client how to keep it as practical as possible, and what we try to do.
Axel, any thoughts on that?
First, we need a new name for the new agreement. So, but honestly, there must be a political solution on the European legislative side, because the authorities, I doubt that they will take a pragmatic approach beyond GDPR. They feel bound to the text of the GDPR, and as long as the GDPR is as it is, they will enforce and execute that. I think there should be a political or legislation solution on the European level, which is not an easy one because of the membership rights. So let's wait for the elections in the US and start new negotiations over the pond then.
Okay. And Tom, do you want to come in? I mean, have you got, what's your top question for us so far?
I think questions come in for Elizabeth, but I think it might be for sort of both the European contingent and grants, which was something you said at the beginning, Elizabeth, about the extraterritorial reach of some of the US surveillance and the way in which servers in the EU might be susceptible to that surveillance. And the question is, can companies take measures against the risk of that data being sort of extraterritorially accessed by the US surveillance laws, and what can they do to mitigate against that risk?
Yeah, that's a difficult question. So it's good to take that into account, and you can make contractual arrangements in your, for example, your data processing agreement that you want that the other party who has then these data, that once there is an access to the data, that the party will inform you as soon as possible, and at that moment that the recipient of the data will then become a controller, because he has to take the decision whether or not to provide the data to the government. So you have to try to find a way that you get informed and see what will be the impact. And so it's difficult. The National Grant already, or Axel mentioned about encryption or contractual measures, but it's here again you see this controversy between the different rules, the privacy rules and the surveillance rules.
Tom, any other?
And Grant, I think I suspect I know the answer to this question, but there was a question earlier about what service providers in the States might do when they receive a request, and what the scope for them, as opposed to the individuals, is to challenge such a request from a government agency.
They can object before the Foreign Intelligence Surveillance Court, but there are limitations, I think, to those procedures that have bothered the ECJ, the Foreign Intelligence Surveillance Court, for example. Its decisions, its records are generally not public and are not open to review. So yes, they can object, but ultimately a judge on the Foreign Intelligence Surveillance Court can order that company to comply with the FISA order or the FISA warrant, and if they fail to do so, they can be subject to contempt sanctions.
Okay, so pretty serious stuff.
Mm.
Yeah. Actually, Axel, one of the things I think, sorry, I hope I say this right, Baden-Württemberg, the regulator there said that if you get you can put on the data importer a requirement to challenge any request for data from government authorities to the last available court. I don't know what that is in America. Is it the Supreme Court? But I saw that as one suggestion they had, whether that's practical or not. Is that right? I think that's right.
Yeah, that's right.
Yes. Yeah.
They
Sorry,
issued, the Constitutional Code. It's right that the authority issued a catalog of like a wish list to build standard contractual clauses plus. So
yeah,
okay. And they might shift the problem to you, Grant. So
okay. And Tom, is there time for one more? Is there a short one we could do?
Yeah, well, possibly partly from me, but it is linked to some question that was raised earlier, which is the news coming out of Ireland. If that is true, that the Irish Data Protection Authority has issued some kind of preliminary order, do you think that's going to open the floodgates in other jurisdictions? Is there a possibility of that happening with regard to standard contractual clauses, or is it just too early to really say anything about that?
I'm going to ask Axel, what will the Germans do? And I'm going to also ask that of Elizabeth in terms of what the Dutch authorities will do. So Axel, the Germans first.
Yeah, the Germans. There are multiple authorities in Germany, so they would first try to align their policy, which is not easy because we have more dogmatic authorities in the north and more liberal in the south. But they will find a solution and probably wait until Dublin has done something, unless one local authority takes the opportunity to make a precedence for the world. So there might be some ambition in Germany.
Maybe Berlin.
Maybe Berlin, yes.
Yeah. And the Dutch, what would the Dutch regulator do you think, Elizabeth?
Dutch regulator sees itself as very important, and they don't keep them strict to their own competence. So what we see, we have now different cases for clients with different establishments within the EU, and although the main establishment is in another country, they take it themselves as competent. You also see it now, just recently they started an investigation to the smart cars, and although we don't have really the smart cars establishment, so the main establishment in the Netherlands, but they still they want more work, and
Yeah.
they will become also bigger. So more people they have employed. So they
Okay. But I think we better leave it there. I just obviously thank the speakers. Thank you very much for all your hard work in putting this together and answering the questions that I put, which I hope were fair. I just wanted to mention again something Jerry mentioned at the beginning about the UIA Congress, which is virtual this year, October 28th to 30th. Please do join us. It'll be fantastic. I've been helping to organize that, so it will be fantastic. I hope you can join us there again, and do log on as well for other UIA events. You'll find that on the UIA's website, uianet.org. So thank you very much to everybody. Thank you to Tom as well for looking after the questions, and see you all soon. Thanks.
Thanks.
Thank you. Bye-bye.
Bye.
Bye.